Welcome to an emergency episode of the Free Speech Unmuted podcast. It's an emergency because there's a Supreme Court case this morning, the NetChoice case, or two combined cases having to do with the Texas and Florida social media laws. I am your co-host, Eugene Volokh, with the Hoover Institution, and I'm here with your other co-host, Jane Bambauer from the University of Florida. And we're going to talk about NetChoice, and we're also going to talk briefly about the Murthy v. Missouri case, also involving social media, but a different matter. So let's start with the NetChoice cases. The lead case is a Moody v. NetChoice. That's how it's going to be called in the books. And this case involved the Texas and Florida laws, complicated laws, slightly different in some respects. Let me oversimplify by describing them this way. The laws provided the social media platforms generally can't block user material because of the user's viewpoints. Florida law was narrower in some respects. The laws are also broader in some respects, but basically that's what it was about. The theory is that platforms shouldn't be able to moderate, or if you prefer, depending what side of the issue you're on probably, to censor material based on viewpoint. The lower courts dealt with this as a question of overbreadth, whether the laws were facially invalid because they were too broad. And the Supreme Court said, wait a minute, that's not a good way of dealing with the laws at this stage, because social media platforms do a lot of different things. They provide what the court called curated feeds, like the Facebook news feed or the front page of YouTube, let's say. And they also provide direct messaging where people can just chat with one another. They also provide a hosting for people's own pages that their friends could visit if they want to. And the Supreme Court said that the First Amendment analysis might be quite different for each of these functions. And that before striking down the law on the grounds that it's overbroad because it's unconstitutional as applied to one of those functions, lower courts have to do a lot more work to figure out if indeed most of the time it's unconstitutional, some of the time, a bit of the time, and the like. This is part of the Supreme Court's broader retreat from the overbreadth doctrine and a shift to asking litigants to basically challenge the law as applied to their own speech, which is pretty much the way you challenge laws under other constitutional provisions. But in the process of this rendering this pretty procedural decision. By the way, all 9 justices agreed that the case should be sent down to lower courts for further determination as to how the First Amendment plays out with regard to all of these functions of the social media platforms. In the process, the majority of the court, in this case it was Justice Kagan, joined by Justice Sotomayor, and also Chief Justice Roberts, and Justices Kavanaugh and Barrett. So that 5-justice majority said that they were pretty comfortable saying that at least one kind of application, one important application of the laws, was unconstitutional. And that's the application of the laws to these curated feeds. Basically, the kinds of places on the platforms where the company that runs the platform is collecting content from a bunch of third parties into a feed that contains things it basically recommends for its users. And that, as to that function, the Supreme Court said, the platforms are pretty much like newspapers or maybe parade organizers who have First Amendment rights to choose what to include in their newspaper, whom to include in their parade, and whom to exclude. On the other hand, as to other functions, the Supreme Court said, or at least the majority said, we're not going to decide that. That's going to be something that lower courts have to decide in the course of determining whether the law is indeed facially invalid because it's overbroad. And it didn't give a lot of guidance, a lot of new guidance as to whether the law is unconstitutional as to those functions. So it's a narrow decision, but an important decision. It is important to recognize that social media platforms do indeed have the right to pick and choose what to include in these curated feeds, even if the court didn't decide whether they also have the right to block certain messages that people might exchange through direct message or by email, or whether a platform could eject a user because it doesn't like the user's speech, just block the user altogether or delete the user's posts. Those were questions the court did not decide. Now, there are a few other interesting twists to these opinions, but I just wanted to ask Jane what she thought about the decision. I should say, by the way, I think that this decision about curated feeds is correct, that platforms do have a First Amendment right to decide what to include in these feeds to offer their users, just like a newspaper has the right to decide that. I think the answer might be different as to direct messages, as to decisions whether to host a particular page or block the user from posting things in the future. And I'm glad that the court didn't fully resolve that issue. Jane, what do you think?
Yeah, well, so first of all, listeners who want to go into more detail on what exactly the Florida and Texas statutes were meant to do can listen to our earlier episode. I think our second episode ever was on this topic, Eugene, or maybe it was our third. It was right after the oral arguments for the case, and we were, I really thought that this was going to be the case where the Journal of Free Speech Law that Eugene founded with me and Ash Bhagwat was going to get its first citation here. I didn't see it though. The very first thing I did, yes, when I read the opinion.
I will say that the
Yes.
opinions did not cite much by way of
legal
academics. I saw one citation to basically a procedural an article about a procedural issue in Justice Thomas's opinion. I saw a bunch of citations to articles about the way social media platforms work and the like. But
the more technical.
This wasn't a time when the justices were paying much attention to legal scholarship or paying much attention. They didn't see any particular need to tip their hat to it.
Yeah, I mean, and yet, you and I could, identify several articles that I think very well could have been cited either by the majority or by Alito's opinion if they had wanted to. So, but that's fine. So you can hear us talk in a little bit more detail about the statutes if you want to. We're really, what we're hoping to do here is to highlight what the court did do and what is left unresolved. I agree, Eugene, that I think this case is going to come to mean two things. One is that NetChoice was penalized in a way for a strategic decision to bring a facial challenge, and the court, the opinions even put it that way, that that decision comes with consequences and a high bar, and I think while stating it, they're actually making. They're actually strengthening the requirements by sending this back and requiring the parties to therefore completely map out the scope of the statute and carefully, have to comply with the idea that they need to show that a good portion, maybe even most of its application would be in the range of unconstitutional. So, but then they also did say that they did make a decision on what substantively a lot of us academics were paying attention to, which is when it comes to content moderation, which was I'd say content moderation and hosting were the two things that everyone had their eyes on because of deplatforming entirely or shadow banning certain content, right? Those were the two terms. Deplatforming and shadow banning were the two concepts that really caught fire in the national imagination. It's the reason that I think we saw these Texas and Florida laws. And the opinion did say something about that. They did decide that ultimately the analogy that won the day was the analogy to a parade organizer who can have a pretty capacious sense of what's allowed in and still nevertheless reserve their right to have the discretion to decide what doesn't get put into the curated parade. I couldn't help, though, looking at Kagan's opinion on the curation function, I couldn't help but see a lot of strong, suggestions that the decision to host or not might also, sort of wind up having to take courts to the same logic. But we'll see, right? That's for the lower courts, I guess, to have to resolve at this point. And then maybe also the case outcome is notable for the fact that the majority opinion was an ideologically mixed group of justices, and that those who reserved judgment include Justice Ketanji Brown Jackson, who agreed that it was right to send this back, but she would not have said quite as much or commented on quite as much regarding even the content moderation function. Now, personally, I'm curious what you think, Eugene. I'm glad they did, because I think that was the big legal question that was keyed up, and that the Supreme Court was, sort of in a good position to answer. So I think it was appropriate, just as every case is not just a holding, and I think it was appropriate maybe to resolve this, but the fact that she would rather not suggests that I think she would be open to entertaining arguments that that the government might have a freer hand when it comes even to content moderation. I could say a few other things about the Alito and Thomas opinions, but maybe I'll let you first react to what I've said.
Sure. Unsurprisingly, I agree with pretty much everything you said. I'm not sure that the majority opinion signals much about this deplatforming question. Can platforms just kick someone off the site rather than just not showing their posts in the curated feeds? But other than that, yeah, this is a decision that has some meat to it, but is also a relatively narrow decision. I did want to flag a couple of other things that some justices said. First of all, 4 justices, Justice Barrett, who was in the majority but also wrote a separate concurrence, and Justice Alito, who was writing for himself and Justices Thomas and Gorsuch, flagged the question whether First Amendment protects AI curated materials. They didn't say, oh, no, AI curation is not editorial discretion, but they said, it's an interesting question. It's one of the things.
Yeah, the fact that they're saying an interesting question means something, doesn't it?
Exactly. They're saying this is one of the reasons we want to send the case back down for more factual development, for more of an as-applied challenge. We'd like to know is how much of the curation is perhaps AI curation and whether that matters. That, it seems to me, is an important signal, and I would imagine that the litigants and the judges down below are going to pick up on that signal, and we're going to see more argument about that question. Also, Justice Barrett had a passage which pointed out that the First Amendment doesn't fully apply to foreign speakers. Foreigners in the U.S. are generally protected by the First Amendment, but foreign persons and corporations located abroad do not have First Amendment rights, as the court held in a case 4 years ago. Well, she asks, what if the platform's corporate leadership abroad makes policy decisions about the viewpoints and the content that the platform will disseminate? Does it matter that the corporation employs Americans to develop and implement this if they do so at the direction of foreign executives? Courts may need to confront such questions when applying the First Amendment to certain platforms. Which certain platforms? She doesn't say it, but it sounds like a signal that for the TikTok case, whole separate case with a very different legal issue in some respects, but it's now pending in the DC Circuit, and it's interesting that she noted that. Let me mention one other thing, mostly for the sake of completeness, because it's not like the court told us that much about it. There is a separate feature of both the Florida and Texas laws that required basically individualized explanations of why certain material was being blocked or removed or what have you. So that was a disclosure requirement. It didn't, that part of the law wasn't the part that limited platform discretion to keep or remove, but it required them to explain that. Well, is that constitutional? The court suggested that maybe this curated feed versus other features distinction might matter. So maybe if it comes to the curated feed, the platforms should be free to not include things without explanation, just like a newspaper generally isn't called to account. Why didn't you run this op-ed? Why did you choose this story? But on the other hand, maybe when it comes to decisions whether to block, whether to remove certain users altogether or block certain direct messages, maybe as to that, the law's disclosure provisions would be constitutional. The court said, well, the focus is on whether those disclosure provisions excessively burden the platform's speech, and whether they do or don't, that's a difficult question that unfortunately we get even less guidance on in many ways than we do as to the content moderation question.
Yeah. Although, I mean, for that, I think maybe one reason they feel like they don't need to comment quite as much is that they rely on Zotterer, among other cases, which was a case that sort of said that when it comes to sort of purely like non-ideological information-based disclosures, it kind of laid out a test. And so maybe they're thinking, okay, we have, at least there's an established test that can be applied. But I found it interesting that Justice Thomas's opinion went out of its way. Obviously, Justice Thomas is skeptical of the majority's decision when it comes to content moderation restrictions. And yet he also said he's skeptical of their reference to Zotterer. And he seemed to say that that, you know, the idea that First Amendment interests are weaker when the government is requiring, compelling informational disclosures than it is when it's suppressing information is suspicious to him. He doesn't think that necessarily is true. So this shows, I think, how hard it is to map out, you cannot rely on someone's sort of political valence to predict how they're coming out in these cases, because he parted ways with both sets to criticize Zotterer there. Right,
and in part because at this point there's very little being decided by the court. Again, the majority does decide about the platform's right to choose what goes into the curated feeds, but the rest is just people sort of saying, well, this is something we need to think about. This is something that might merit reconsideration. So it's easy for people just to flag this as an issue, leave it to lower courts, and maybe when the case comes back, if it comes back, to consider it then. So, well, that's NetChoice. Tells us something, doesn't tell us a vast amount. But there's also the Murthy case. Jane, you tell us about Murthy. What happened there, and what do you think about it?
Okay, so this was a case we also discussed previously on our podcast. This is the case in which 2 states and several individuals, based partly on the Twitter files revelations, brought a suit requesting an injunction against various parts of the federal government, the White House, the CDC, and the FBI and a few other agencies, because for exerting pressure on the social media platforms to demote certain content or remove it altogether. And so the Fifth Circuit, the Fifth Circuit came up with a test that was trying to establish whether the government, basically whether there's state action here, right? So if Facebook or Twitter decide to demote or remove some content, but they're doing so under some influence of the federal government, can we say that that the government itself is acting through these intermediaries? The Fifth Circuit came up with a test that I didn't think was perfect, but in our podcast, I think I said that I thought it was pretty good. The court clearly was a little bit skeptical. We both at the time, Eugene, thought they might just dump this very complex case on standing, and that's exactly what they did. So in fact, Justice Amy Coney Barrett, writing the majority opinion, says we begin and end with standing. So that sort of tells you everything you need to know. And basically she thought, look, to get standing, especially in a case that's asking for injunctive forward-looking relief, there are a couple things that can get in your way. One is that you need to show that the injury really results from the government's action and not from some third party. And so in a way, that means that standing is going to have a little bit of a microcosm of what the case was all about in the first place. Like that by having to prove that the government caused ultimately a decision by the social media companies to demote some content, the claimants need to show that if it weren't for the government's compulsion, interaction, whatever you want to call it, the social media company would have done something else. And then the second principle is that even if the parties had persuaded the court that in the past some of their posts were demoted because of something that the government did that may in fact have been coercive or may have, may legitimately raise the question of government action, because they're asking for forward-looking relief, an injunction, an order to the government to not do anything like this in the future. Those past incidents are at most just sort of a probabilistic, it's just some evidence of a probability that they may occur in the future. And so the fact that they may have happened before doesn't mean that they will happen again. And the plaintiffs need to come with a little more evidence that it's likely to happen again. So that's what they decided to do with it. I think given the complexity of the case and the sprawling facts and even the disagreement, it seems, on the court about whether the factual record developed in the trial court and Fifth Circuit was developed well, it's probably not surprising that they wanted to stop this particular case before deciding on the merits and coming up with a test on these sort of jawboning cases. I have to say, I'm a little disappointed, though. It does seem to me to be kind of a punt for an issue that may arise again. And I think the burden, I guess it takes me to the edge of my understanding of civil procedure. But I thought that since the nature of this is that there may be a First Amendment violation here, this isn't merely some kind of, it's the sort of case where usually compensation is not enough. Injunctions usually make a little more sense, even based on past action. I don't know. I thought this maybe was a little bit of a stretch from what we've seen before in standing. Eugene?
Yeah. So, I'm not a civil procedure expert either, but just stepping back, just to think a little bit about standing, there's something unconstitutional the government is doing. Before you can challenge it, generally speaking, you have to show that the government's unconstitutional action actually hurt you, and that you weren't hurt by something else, you were hurt by it. And then maybe in some situations you might get damages, in other situations you may get an injunction if you can show that the government's action is likely to hurt you as well. So the result can be kind of frustrating for observers. They say, well, wait a minute, here's this thing the government is doing. Must have hurt somebody. That is to say, must have caused some people's posts to be removed. I mean, why would the government be asking the platforms to remove certain material if they weren't hoping that some material would be removed? Why not just decide whether that's constitutional or not, so we know whether the government was acting within its lawful powers? And generally speaking, the Supreme Court has said that's not good enough. It's not the job of the courts or of the Supreme Court to step in every time there's some possible injustice. You have to have the right person suing over it, developing the facts and showing that they're the ones who were hurt and they have a personal stake in the matter. Again, this is an oversimplification. It's a bit more complicated for injunctions, but that's what the court said was missing. So now we have a situation where people still think that what the government did was wrong. other people may think that what the government did was right because it's good for the government, or at least permissible for the government to urge platforms to remove certain things this way. But most people agree that there were some posts that were removed as a result of the government action, and not just completely independently of the government action, but we don't get a decision as to whether that's constitutional or not. That's just a side effect, though, of the general rule that a court can only step in when the plaintiff can show that the plaintiff himself or herself was actually harmed this way. So that's how the court decides the case. Unsurprisingly unsatisfying in many ways, but I think well within the general mainstream of how the court has dealt with similar questions in the past.
Yeah, and I will say, now that I've heard you kind of describe it that way, there's one way of understanding this case that I can kind of get behind, which is, at the very least, standing is sort of a minimum requirement, not only about who, but about whether there really was in something that we might recognize as an injury. And so if the parties can't even show a factual causal link between whatever it was that the government did and the end result of them, their post being demoted or something, then the next question, which requires more than just a factual causal link, but it asks, okay, well, even if the government did cause, in some sense, this action, was it mere influence or was it coercion? At that point, then we split. Causation can be legitimate or it can be illegitimate. But if you don't even get the baseline of causation, then perhaps it makes sense that we don't have the factual record to really think through whether that, whether their influence was just or not.
Right. One way of thinking about it, there was a case 60 years ago now, Bantam Books versus Sullivan, which dealt with a structurally similar question. Obviously, the facts were very different, but there was a state government entity that basically, the allegation was, and I think it was established, that it had threatened bookstores with criminal prosecution. Not by the agency itself, it didn't have the power to do that, but by calling in the police and prosecutors, threatened the bookstores in order to get the bookstores to remove certain books that the agency thought were unsuitable for children. And the Supreme Court said, well, that's not an actual prosecution, but it's enough of a threat that it's coercive enough that it should be set aside. But there, in part, it was quite clear the bookstores had the books on the shelves that already decided, they had to make a conscious choice back then. Bookstores did. It's not like social media platforms where anyone can post things. The bookstores had to decide to carry the books. They had carried the books. The only reason to think, the only plausible reason why they would remove the books was the government threatened them. And in fact, if the government threat went away, then it seems very likely that going forward, the bookstores would stock the books again. So there's a classic, very nicely teed up example of threatened government coercion. And then the question is, was it coercive or not? And the Supreme Court said, yes, in context, it wasn't merely a request. It was really coercion. It was unconstitutional. But there, the right parties sued. They sued over something that was an injury to them, and an injunction would redress that injury, would prevent that injury going forward to them. So the Supreme Court had no problem with the standing in this kind of situation. But in the Murthy case, the court said, the facts are much more ambiguous, and at least these plaintiffs, you haven't persuaded us that they were hurt by the government action. And more importantly, because it's an injunction, that going forward, the injunction was necessary to prevent future harm to these particular plaintiffs and would succeed in preventing future harm to these plaintiffs.
Right. Yeah. Yep.
Well, all right. I think we agree. I was about to say unusually, but that's not right. We usually agree, partly because we're both such reasonable people, Jane, you and I, and reasonable people should agree on such things.
Well, also, right now we're just trying to describe. So if we were actually making policy decisions, maybe then we'd start. But it is good to know that we can read the same opinions and come out describing them the same way. That is something.
That's right. I remember I was talking to a colleague of mine some years ago, around the end of the semester when we were grading exams, and he said that he had, by accident, put an exam that he had already graded back into the pile and regraded it. And then at the end,
Right.
he saw it and he said, "Oh, the scores were only like a couple of points apart." That made him feel good that his grading was at least consistent. So
Yes.
here it's two different people, but it's good to know that we as First Amendment scholars are consistent, at least in our description of what's going on, and perhaps our general evaluation as well. So that gives, I hope, gives our viewers and listeners some sense of what the court did, rightly or wrongly, in the NetChoice cases, what the court did rightly or wrongly in Murthy. And we'll be back next time talking about other interesting free speech issues. Jane, always a great pleasure talking to you.
Great to see you, Eugene.